Salt and Light Global is a ministry. You know how Paul made tents? Well, I'm a law professor and I teach constitutional law, but that's almost in a way, as Paul made tents, that's what I do. Our real calling is to listen to what Jesus said, and he calls us to be salt and light. And salt preserves and it savors, and light illuminates darkness, doesn't it? And you have heard this morning about an invading and a pervasive darkness that is out there. So what we want to do is we want to take some time this morning and illuminate that darkness, because you may be heard, because I can tell you all are church folk, and I love that, and I already can tell that I've got a couple amen corners from that first presentation. So and that's going to be important, I think, in the future. And as Christians, you know that darkness never overcomes light. It's impossible. As a scientist, you know that darkness can never overcome the light. Even the smallest, I shut this whole room dark, even the smallest little light would pierce that darkness. The darkness can never overcome the light. And if that place that we are at is not shining, if there is not light there, it is not because the darkness has overcome the light. It's because we are not shining our light into it. And so this morning, I want to share a little salt, and I want to bring a little light. And I want to thank Americans for Decency. I want to thank Bill. This is what we need. We need all over this great country people getting up early in the morning and coming to conferences like this, because when you come to a conference like this, you become educated and you become empowered, and when you become empowered, you can share with others, and when you share with others, that little teeny light that's piercing the darkness becomes really, really bright. So that's what we're going to do this morning. You heard a lot. I'm going to bring you into my classroom, in my con law classroom. We are going to have a little mini session on constitutional law. And the reason we're going to do that is because I want to then take everything you heard earlier this morning and take what you now know about our constitutional system and put what you just heard this morning into that context and see if it fits. Because I can tell you, the folks that are representing the interests that you heard about this morning, they've got very good lawyers, and they've got hundreds of folks in hundreds of law schools memorizing and understanding the American Constitution with an eye toward impacting the way this country will be governed in the next 100 years. Which suggests to me that those of us that have a traditional worldview of governance, that is, that there is good governance under the rule of law, that is, when our founders said, we hold these truths to be self-evident, that all are created equal, endowed by their Creator with a capital C, with certain unalienable, that is, sacred, unchanging rights, including life and liberty, that they were looking to some standard. They were looking to some moral absolute with which they could govern their own personal conduct, but more importantly, for the purposes of governance, with which they could govern a nation, where we could look at the exercise of government power coming out of buildings like this and measure that government power and measure that government action each time to decide whether or not that government action is good or bad, right or wrong, just or unjust, constitutional or unconstitutional. Where does the Shariah fit into this? Because I can tell you, the lawyers that represent the interests that you heard about earlier this morning, they are coming into courts throughout the United States every day, and they are arguing, if you do not give me the right to have halal meat in the state prison, served to everybody, you are violating the free exercise clause of the United States Constitution. If you do not set up an official separate court, Sharia court, to do divorce cases, and handle other certain matters that we deem to be part of our religion, you are violating our free exercise of religious conscience. If you do not give us special understanding in our banking system and allow us to implement Shariah finance principles, you are violating the free exercise clause of the United States Constitution. Let's see if they are right, because I can tell you that judges are listening to that argument. And I can further tell you that we in America have gotten so far away from those founding principles that even the lawyers that agree with us don't know how to make the argument. And part of the battle is that, we've been talking about an attack on our rear front, all right, from our rear. And part of the problem is that we've been so preoccupied with an attack on our left. Our left flank has been, and pardon the pun, but I mean literally from the left in America, has been attacking us on the left flank, arguing for a secular system, arguing for a secular America. And we've been so preoccupied with that battle, we have not even seen what's being put together on our rear flank. And I want to put all this into a constitutional framework so that when you leave here today, you're going to do a better job than the guy that was on Fox News this morning as we were driving here. Apparently, and I didn't get to hear the whole story, but there's a cross that is being attacked again by the ACLU. No surprise there. But the guy that's on a national television station, a national program, gets up and justifies that cross as being there because it's secular. Well, if you look at the bottom of the cross, it's got the name of our organization here, and it's got this other secular reason here, and this other secular reason here. Well, if the reason that cross has to stand up there is because it's a secular symbol, then we've lost the war. Forget about the battles. We have to go back to our founding principles, and we have to understand the American Constitution as it was written. And if we do that, not only will we be able to handle the battles and the attacks coming from the secular left, but I think we'll be very effectively capable of handling that new attack that we see coming from our rear. All right, our founders knew that God was our source of our liberty and rights. We hold these truths to be self-evident, that all are created equal, endowed by their Creator with certain inalienable, sacred, unchanging rights, life and liberty. Now, we see the promise of the Declaration woven into the structure and the text of the American Constitution. Let me show you how it works. I bring my Constitution with me wherever I go. And when I was working as a legal counsel in the United States Senate, I ran into a United States senator in the elevator one day, and he had a Holy Bible in one hand, and he had the Constitution in the other. And I looked at that, and I said, wow, what a statement. Nobody else around, no press or anything. And he said, you know, these two things is all you need if you want to lead. And I got to tell you, ever since the iPad came out, though, it's a whole lot easier carrying that Bible and this Constitution around. But for purposes today, we're going to use this. Let me show you how it's supposed to work. See these buildings here, the White House and the United States Congress? Before anybody that works in either one of these buildings, thank you, is allowed to act, is allowed to exercise power in any way, they have to go to this Constitution. This Constitution for the American government is a power source. And that's why I bring my power club here. This is going to represent the exercise of government power. All right? The way it's supposed to work, if anybody lives in this building or works in this building, before they act, before they exercise power, before they use power, they've got to go to the power source. And they have to very carefully look and see where they are authorized power and where they are not. And so, for example, the Affordable Care Act, Obamacare. The whole issue before the Supreme Court was whether Congress, had gone to a proper power source. Now, what the president didn't tell you was that the power source that he used was the taxing power, the power to tax the American people. That was the basis for Obamacare, for the act. They had to have some power source to plug into. He didn't tell you that because that wouldn't be very popular. But I can tell you, you know where he did tell you that? He sent his Solicitor General to this building here to make an argument in front of the Supreme Court that Obamacare was constitutional, and the argument that he made in the Supreme Court that the power source we plugged into was the power to tax the American people. Now, I'm not making any of this stuff up. This is all public record. You can go check it out. Very easy. Go watch the arguments. Go read the briefs. Anyways, you're getting the idea. Before government can act, they have to plug into a power source. All right? So far, so good. Well, what if government acts in such a way that substantially interferes with the free exercise of your religious conscience? Or what if government passes a law that says you cannot speak on certain topics anymore? What if government passed a law that said you could not raise your children in the way you wanted to, but that you had to send your children to a government school? What if government used its power in such a way that they just showed up at your house and said, you know what, we're going to put some soldiers in your house today? And you say, well, I don't like that too much. Well, so then they arrest you and take you away, and they don't give you any due process at all. In all those situations that I just described, we saw the exercise of government power, didn't we? All right? Now, you notice at the end of this power plug has got red tape on it. Well, that's representing law and government action, because government does what? They make a lot of red tape. So when you see this red tape today, that's going to be representing the exercise of government power, a law, okay? Now, even assuming that government has plugged into an appropriate power source here in the Constitution, even assuming they've done that and that they're acting within the scope of that power source, the next question becomes is the government using that power in such a way that is substantially interfering with one of our inalienable rights, with one of our freedoms? And so not only does government have to have a power source, even if they have a power source, they cannot use that power in such a way that interferes with the free exercise of your religious conscience. They cannot use that power in such a way that interferes with your freedom of speech. They cannot use that power in such a way that would establish an official government religion. Y'all with me so far? That's how it's supposed to work. All right? And if you read the Constitution, our founders were brilliant. It literally is nothing less than genius. They put together a constitutional framework, a blueprint, if you will, for how to govern a nation. And if you follow that blueprint, it works. Haven't said much about folks that work in this building, though, have I? Well, what happened since the founders wrote this document is right from the very beginning, the folks that work in this building have decided, they said, you know what, you didn't give us, when you listed all those power sources there, you didn't give us any. You didn't give us very much. You gave us the power to decide disputes and controversies and cases and controversies. And you know what, you give a lawyer even an inch of power. And it doesn't take them very long to figure out how to get a whole lot more. And so what the court has done from the beginning of time is it's designated themselves as the branch of government that gets to decide what this Constitution means, including what your liberty means, including what liberty is. And so the constitutional provision that says Congress shall pass no law respecting an establishment of religion or the free exercise thereof, all of a sudden becomes something very different. Let me start where it was, though. Where it was is Congress shall pass no law respecting an establishment of religion or the free exercise thereof. Why did our founders say that liberty was self-evident? Well, because God says what? It's placed on our hearts. God puts the law on our hearts. We can look at a self-evident moral absolute to decide right and wrong, good and bad, just and unjust, constitutional, unconstitutional. Don't establish an official government religion or an official version. Don't humanly put yourself above God and say you know what the best religious approach is. And at the same time, allow for the free exercise of religious conscience. So now you're all, for the most part, probably in here Christians, I'm guessing. But you probably don't all go to the same church, and if you get down to it, you all agree on the most important thing, but there are some doctrines that aren't as important with regard. They don't have to do with salvation, but we could very quickly get into some debate here. Whether we're talking about communion or a lot of different things, right? We're not going to go there. But that's why we have the free exercise clause and the establishment clause. Together, it was a genius. It was genius. We are not going to have a war among ourselves. We're not going to establish an official government, religious government. At the same time, government cannot do anything that's going to interfere with the free exercise of your religious conscience. So we can have those differences and have those debates without having a war. All right? Now, what happened was, long story short, is the Supreme Court. Let me tell the story, because the story is really good in how it happened. There was a Harvard president, and he was not a Christian, and he wanted to remove the Greco-Roman Judeo-Christian worldview influence from the law. All right? And so he set out to do so. And the reason that he wanted to do that, he read Darwin's Origin of the Species. And he said, wow, this evolving thing, that works, I think that looks pretty good for biology. Let's apply those principles to the law. So he hired the dean of the law school with the sole purpose of removing these moral absolutes and an idea that there was a right and a wrong, remove that idea from the law and replace it with an ideology, a philosophy that is called legal positivism, where no person's values are any different than anybody else's. There is no moral absolute. There is no right and wrong. Basically, whoever in power gets to decide what the standard is at that point. And if you ever want to have some fun, if you got some really smart professor that comes into a room and gives the Harvard accent and says, there's no moral absolutes and you must be stupid if you think so. Just ask him if he's absolutely sure. Because he's just stated an absolute, hasn't he? Well, what the court did is it moved to a new philosophy that was very different than the founders' philosophy. There was no longer any self-evident truth because now there was no longer truth. So now the standard had to be set by those in power. Most often by those that work in this building, in the Supreme Court. And so now, instead of the free exercise clause, Congress shall pass no, or the establishment clause, Congress shall pass no law respecting the establishment of religion, or Congress shall not pass a law that interferes with the free exercise of your religious conscience. Now we have to redefine what that means. And so judges in this courtroom took those words that says Congress shall pass no law respecting an establishment of religion, which, if they mean what they say, you can't establish a religious government, and said, you know what, we're going to say that really means that government must have a secular reason for everything it does. Government must have a secular reason for everything it does. And so, now, if you go to your congressman and you say, you know what, in the beginning God created man and woman. And he made him in the very image of God. And he said, I saw what I made and it was very good. And I have a plan for your life. And because I made you in my image, your value is so precious and so inherently precious that thou shalt not kill. If you go to the legislature and say, because of that sacred standard, that self-evident truth, I think we need a law that prohibits a physician from assisting somebody in killing another person. And that legislature passes that law and the governor signs it, okay? Now suppose if that law goes to the Supreme Court under this new definition of the Establishment Clause, instead of the Establishment Clause meaning you cannot establish a religious government, it now means you have to have a secular reason for the law. Well, guess what's just happened? Your law is now unconstitutional, not because of what it says, but because of the intent or the reason behind it. It was a secular reason behind it, which is why our misguided guy on Fox News this morning, bless his heart, he was up there defending a cross, saying it's a secular symbol. He was doing that because he felt he had to do that because otherwise the Supreme Court might not agree and make him take his cross down. Now, another person in another state, perhaps as a physician, and comes to the legislature and says, you know what, the medical profession is called to heal. It's not called to kill. And if physicians are assisting people in killing each other, that's going to hurt the reputation of our profession. Therefore, Madam Legislature, would you please introduce a bill that prohibits a physician from assisting in suicide? And so that legislature writes the exact same law, word for word, the periods and the capitals, everything in the exact same places as the previous law. Guess what? This time that law goes all the way up to the Supreme Court, and the Supreme Court's going to say, no problem, okay, it does not violate the Establishment Clause. And so we in America, especially the Christians in America, have been very upset about what the Supreme Court did with that Establishment Clause. Because it's stopped us from exercising our free exercise of religious conscience. If we want to put the Ten Commandments up, we have to put a lot of other stuff around it so people think it's a secular display. If we want to put Jesus in a park, in a manger at Christmas time, we got to put Rudolph and Frosty the Snowman and everybody else around him so that somebody in ACLU is not going to file a case saying that you are engaging in a violation of the Establishment Clause. And so the lawyers on our side, and they're good folks, have been fighting these battles for so long in the context of a secular foe. We have characterized all these battles involving the Establishment Clause with our worrying that they're going to force us to not be able to have the free exercise of our faith. And so guess what? A number of organizations have even taken up the causes of folks that you heard about earlier this morning. Because in their mind, they believe that if you stop a Muslim advancing Shariah, that's the same as stopping a Christian from exercising the free exercise of the religious conscience. And if you stop one person from having the free exercise, that damages all religions. All right? Sounds logical. But there is a major flaw. And I want you to hang on to that thought, that there's a major distinction. And we're going to talk about that in a minute. But before we do, I want to share with you the other thing that the Supreme Court did with the First Amendment. Because not only did they recharacterize the Establishment Clause, they recharacterized the Free Exercise Clause. All right, now let me show you what happens. Under the traditional approach, and the way it was in this nation for years, if the government came in and used its power and came in and told you that you couldn't send your children to a religious school, but you had to send them to a government school, you with me so far? Think that could ever happen in America? I'm here to tell you, it did happen in America. It did happen in America. A state passed a law, said you couldn't send a kid to a religious school, you had to send them to the government school. All right? It happened in America. But it happened in a time in America when the folks that worked in this building treated your free exercise of religious conscience as an unalienable liberty, a self-evident truth, that we would measure a government action like that. And any time the government interfered with your free exercise of religious conscience like that, the court would bring out its microscope. And I call it the strict scrutiny microscope, because under the law, that's what we call the type of scrutiny that the court gives a government action that interferes with some fundamental inalienable right. And so the court put that law under the microscope, that you cannot send your child to the government school. And when the court put that under the microscope, that means that the government had to come forward with a really compelling reason for interfering with free exercise of religious conscience, and that they had to show that they were using the least restrictive means absolutely possible to achieve whatever that compelling government interest is. Guess what? The government failed miserably on both counts. And so when you applied strict scrutiny to a government action that interfered with the free exercise of religious conscience, that law, that exercise of government power, struck down over and over and over again. Let me tell you what happened more recently. The Supreme Court said, well, maybe we won't bring out the microscope all the time. All the time. And what happened was the government used its power again, this time to make a law that substantially interfered with the free exercise of religious conscience. It was a law that said you could not use peyote, which was a controlled substance. All right. Now, peyote was used by a number of Native American groups as part of a religious ritual. All right. It was part of their sincerely held belief that they would use this substance. All right. Now, the problem with Supreme Court decision making is they always take some crazy case like that, with crazy facts like that, to make horrible law. Let me just change the facts just a little bit to put it into context. I'm not going to change the essence of the decision, but I'm going to just change. Instead of peyote, let's say it was wine. And instead of a Native American ritual, let's have it be communion on Sunday. Same thing, same exact facts, all right? What the court said was, because, and let's say you could picture government passing a law that says no consumption of alcohol on the weekends. We've got an important interest here. People are drinking on the weekends and they're getting in accidents and they're causing, accidents. And that's why we have a government interest in passing a law that says no drinking on the weekends. Let's say government did that, like they did in the peyote case. Well, if a pastor attempted to give communion on a Sunday and the police showed up like they did with the peyote and arrested him, well, our religious liberty lawyers would be all over it, wouldn't they? We would come up and say, you're violating the free exercise of religious conscience here. Well, let me tell you what the court did. The court said, well, you know what? It may say that Congress shall pass no law respecting the free exercise of religious conscience, but we read this to mean something different. We say that since this law was neutral, it was written in a way that applies to everybody, and it was generally applicable to everybody, even though it substantially interferes with the free exercise of a religious conscience, we're not going to do what we normally do. We're not going to bring out the microscope. We're only going to eyeball that law this time and say, do you have a legitimate government interest for doing this? Well, yeah. Stopping abuse of controlled substances or stopping drunk driving or whatever. Now we've got a completely new system where now government can use its power in such a way that would interfere with the free exercise of religious conscience, and the court's not even going to bring out its microscope. Well, guess what? When it happened, people like you actually did really get informed for a while, and we all got informed for a while, and we got on the phone, we got on the, it was just before the internet, but we shut down the phone system in those buildings over there. And Congress heard from us, and then they passed a law called the Religious Freedom Restoration Act, which says, no, court, when you mess around with religious freedom, and you've got a case in front of you that involves a law involving religious freedom, we want you to bring out the microscope. So Congress passed a law that says you got to, at least, and long story short, at least at the federal level now, you've got to bring out the microscope. how is that all relevant to our meeting here today? Well, if somebody said we couldn't administer communion, we'd get all upset. If somebody said we couldn't send our child to a religious school, we'd get all upset. And we'd say that violates the Free Exercise Clause of the United States Constitution. And so guess what? That is exactly what the Shariah lawyers are arguing when they're arguing about madrasas, when they're arguing about halamit, when they're arguing about Sharia financing, when they're arguing about Sharia courts. They are arguing, if you fail to do this, American government, you violate the Free Exercise Clause of the United States Constitution. Because the Free Exercise Clause forbids substantial interference, and now we know that the Religious Freedom Restoration Act, a statutory cause of action, also prohibits the free exercise of religious conscience. How do we respond to that? We have to understand Islam. And thank you, Mr. Gaffney, for what you did earlier. There was one PowerPoint slide in there that was particularly important to my presentation today, and that's the PowerPoint slide that very clearly showed that Islam, while it is a religion, you need to understand it in the context that it's not just a religion, it is also a government. Now, the Free Exercise Clause of the United States Constitution may protect the free exercise of religious conscience, but the Establishment Clause prohibits the establishment of a government religion. Now, there's two ways we can go about this strategically in a constitutional sense. We can go the way of the far left, and we can adopt the view of the Supreme Court in the Lemon case, or not the Lemon case, but the Lemon case that says you have to have a secular reason for the law. And we would probably win under that argument. But if we do, what have we lost? We've lost our right to participate in government. We've lost our right to go to a state legislature and be informed by sacred principles. If the law of the Establishment Clause says you can only be informed by secular principles and you cannot be informed by sacred principles, that keeps everyone in this room from participating in government, doesn't it? But it's a pretty effective tool to stop the rise of Sharia, because they certainly don't have a secular reason for the law. So what do we do? Well, I suggest that we adopt the view of some of the other Supreme Court justices, and we look at the Constitution, and we go back to the Establishment Clause and reread the words of it, and we say, how about less enforcing that clause as it's written? How about enforcing that clause as it's written? Because if we enforce that clause as it's written, that says you shall not establish a religion, a religious government, that stops radical Islamic governing authorities from implementing the Sharia as the law of the land in the United States of America. We have to be able to articulate that argument, though. And I brought a book, too, and I tried to make it small intentionally. And I want every one of you to have it. It costs us a lot to print it and stuff, so any donation you can give, I'd want you to take it, though. Any donation you can give to cover the travel and the printing of it's appreciated. And if you can afford to pay for somebody else's that maybe doesn't have the resources, I'd like to have as many people take this today as possible, because you will hear what we're talking about today, but if you're like me, tomorrow I'll say, wow, that was kind of an exciting presentation. I got fired up, and now what did he say? But this will give you a guidebook on how to respond and how to, adjust and make these arguments. We can win this battle. Because it's an intellectual battle, it's a legal battle, it's a constitutional battle, and it's not just a constitutional battle versus the Judeo-Christian Greco-Roman vision for America versus a Sharia vision. versus a secular vision, it's a battle for the very essence of who we are in this nation. Because one of those three philosophies is going to prevail probably within the next decade or so. One of those three philosophies, we are at a point in our nation that there's not much time left. For such a time as this, if you've ever felt compelled to getting involved, if you've ever felt compelled to participating in the process, if you've ever felt compelled to taking time and reading that big book of his back there and reading this smaller book here, now is the time. And I am absolutely convinced that with each point of light piercing the darkness, we bring a stronger and a stronger and a stronger argument. Now, I want to go through a couple of points just to show you that I'm not making this stuff up. Here's our standard. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, you can go to another part of our Constitution, not quite as familiar with it for everybody, but under Article 6, it says, no religious test shall ever be required as a qualification for office or public trust in the United States. Go see if you find that in some of the countries in the Middle East. Now, I want you to make sure you understand that that this is not a secular position, though. Because it's talking about they must be bound by oath. What is that referring to? Why, even though we don't have any test, a religious test, why is a person to be bound by oath before they're given the privilege of exercising power? Well, I had the privilege of serving in all three branches of the United States government. And before I was given the authority to exercise power, the privilege to exercise power as a judge, or as a United States prosecutor, or as a diplomat, I had to put my hand on the Holy Bible, I raised my other hand up, and I promised and affirmed to uphold the Constitution of the United States of America, so help me God. Why did I take that oath? It was to remind me that I was being given the privilege to exercise power, but in the exercise of that power, I was always to remember there was a higher power. And that I was to exercise that power consistent with those self-evident principles we've been talking about all morning. Not a theocracy at all. Very different than a theocracy, isn't it? It's a form of government that allows everybody to participate in the process. If you are informed by secular viewpoints, you can participate in the American system. If you're informed by sacred viewpoints, you can participate in the American system. But being informed by sacred principles is very different than attempting to establish them as the government of the United States of America. And that is the major distinction that we have to understand in a constitutional sense today. And if you've got friends that are sitting on the bench somewhere as a state judge or a federal judge, please let them read this book. Sit down and talk to them and tell them that difference. Now, they're going to say, well, but how do we know that that's what these jihadists want us to do? And I say jihadists not in a violent form, because there is that form, but there's also the very peaceful form that you heard about this morning, where you can infiltrate the government, you can infiltrate the law schools, you can infiltrate the schools one at a time, master the system of government with which you're in, and then take it over. How do we know that that's what is happening? Well, don't take it from me. Take it from the Muslim cleric, the head of the European Council for Fatwa and Research. He says, Islam entered Europe twice and left it. Perhaps the next conquest, Allah willing, will be by means of preaching and ideology. The conquest need not necessarily be by the sword. Perhaps we will conquer these lands without armies. We want an army of preachers and teachers who will present Islam in all languages and all dialects. Now, the chairman of the Council for American Islamic Relations, he says, Islam is not in America to be equal to any other faith, but to become dominant. The Quran should be the highest authority in America, and Islam the only accepted religion on earth. The head of Islamic for UK. Says, our objectives are to invite the societies in which we live to think about Islam as an alternate way of life, and ultimately, as well, to establish the Shariah on the state level. I've got citations. I got these guys on videotape. If you don't believe me, this stuff is there. You can look it up yourself on YouTube. You don't have to take a constitutional law professor's word for it. If the people that are leading the cause on the other side mean what they say, then we need to take their words, and which say we want to establish a religious government, and apply it to the American constitutional system. When I wrote this thing, I've probably given it to, or at least presented the position to at least 50 constitutional law professors around the country. Every one of them agreed with my constitutional analysis in there. Not one of them would write a thing. Not one of them would write it down. We've got to stop whispering in America. We've got to stop our tails between our legs in America. Let me show you what this turns into when you have a fully mature version of what Mr. Gaffney was talking about earlier. The Arab Republic of Egypt is a socialist democratic state based on the alliance of working forces of the people. The Egyptian people are part of the Arab nation and work for the realization of this comprehensive unity. Islam is the religion of the state. Arabic is its official language, and the principal source of legislation is the Shariah. These are the constitutions. These are constitutional provisions. These aren't statutory laws. These are constitutional provisions. Islam is the official religion of the state and is a foundation source of legislation. No law may be enacted that contradicts the established provisions of Islam. If you were wondering how serious the threat you heard about earlier this morning is, this is what it looks like when it's fully mature. This is what it looks like when it's fully mature. It's in its infancy here in the United States. And I commend you to the different books and sources that are out there, because there are many places where the Sharia is already being implemented. If you go into Minnesota, the majority of banks, well, I'm not an expert on this, so somebody should check it out, but look how many banks in the state of Minnesota are Sharia compliant. Look how many judges are relying on these laws, which must be what? Enacted consistent with the tenets of Islam. If we deny a Sharia court, are we denying the free exercise of religious conscience? Or are we stopping the establishment of an official government religion? No doubt, we need to learn how to recharacterize that argument. Because I'm telling you right now, even the religious liberty folks, many of us on our side haven't got it yet. And we're still looking at the argument as a free exercise clause argument. This is not a free exercise clause. This is very different than a Christian or even a Muslim or a Jew or anybody else attempting to influence legislation because they are informed by some sacred principle. That's not what we're talking about. That should happen in America. We should be able to be informed by whatever principle, sacred or secular. What the folks that you heard about earlier this morning are attempting to do is something very different than that. When they put a Sharia court in and they have the official sanction of an American court in doing so, or an American government or a state government in doing so, they have just placed and established a brick of their government, a corner of their government. That violates the Establishment Clause under any interpretation, whether it's a liberal interpretation or a more conservative interpretation. I suggest we do not use the secular approach to fight Islam, because by using the secular approach, we also prevent ourselves from participating in the American process. We should say, though, that the conservative approach that says you cannot establish a religion, and that basically says you're just not allowed to establish a religious government. You cannot have a law that coerces somebody to practice one religion over the other. All right? And that approach is much more accommodating to folks like us, isn't it? Quite frankly, it's also accommodating to any peaceful Muslim or Jew or Hindu or anybody else as well. We need to make the distinction. We need to make the distinction. If we don't, this is the road we're on. And while we are in infancy here in the United States, and Mr. Gaffney can probably point you to a lot more examples than I can of things that are happening here in the United States. If I take you to England, where I've lived and fought some of these battles, or take you into Europe, other places in Europe, they're at the adolescent stage. They have Shariah courts now in some places. All right? And so you can see the entire process. You start here in Dearborn in the United States, and you proceed into Europe, and then you proceed over into Iraq. Now, we had an American law professor, believe it or not, help him write that Constitution. Where do we go from here? Got to hit our knees. We got to get educated, and we got to respond. And that's how I'm going to leave you. I challenge each one of you to be one of those points of light. It's going to take a little time to do this reading, but then if you tell 10 people and you get one of those 10 people to do the reading, we can change this. We can change this, because I can tell you there are places around the world that are at the adolescent stage now having a little buyer's remorse here. They're starting to see the cost of their incorrect decisions here. And so let me also, when I send you out, that I send you out as Christians. And I challenge you to let them always see Jesus in your heart in the way you do this. Because if you approach these issues in a way that is interpreted as hateful or as angry, you will not even bring a fellow Christian into the fold. They always have to see Jesus in your heart when you do this. We have to do it in a respectful way. We have to do it in a way that I think we've just kind of outlined here, a matter of fact. And I've talked with Muslims. I've been on panels. I don't want to say debating, because they don't like to debate, but they don't disagree with what I'm saying here. They may not like the way it's being presented, but you've heard it in their own words. So, if what our founders said they believed, and what our Constitution and our Declaration says is true, and what the leaders of jihad say is true, if we can accept them at their word, we now know how it fits in the constitutional context. Go out, be salt, preserve what's good here, provide and savor it, and then be light, and let the world know what they need to know, and do it sooner than later, and God be with you as you go.